This is Raquel. So it's on a Saturday and I'm all in my chill outfit, right? Because there ain't supposed to be any work today. But anyways, say hi to Bella. Hey Bella! Bella! Oh, there she is. There she is. I just wake up from her slumber. Anyways, as many of you know, right, I'm also a law professor. I've been a professor for about 23 years. I teach business law, and I'm also a practicing attorney, which is why you see all these wills, trust, and estate. And no, I'm not part of the Hillman Talk University yet, but I'm going to put in my application, god darn it, okay? Nevertheless, I'm here to answer a question. Someone asked about if I can explain how is it that the court was able to block the administration policy on birthright citizenship. So the United States has two tiers, right? We have state courts and federal court, and each court have the lower court, the appellate division, and the highest division. And so because this case is a federal law that's being challenged, they start in federal court. And so we are a common law system, right? And so this common law system was continued from the colonies, right? So the colonies were like satellite locations of Great Britain. They were Great Britain here. So when they won the American Revolution, these 13 colonies, these first 13 states, when they won the revolution and they had to create their own country, which is now called the United States, all the colonies united and called themselves the United States. They kept that which they knew, and part of that was the court system, which was common law. Now, common law has what we call precedent, and so the judge is bound by the binding authority. So if it's state court and you are at the lower level of state court, the judge is bound by previous decision from the appellate state division or the highest state court or any of the courts in the federal level. And if it's a federal court, they're bound by the appellate court or the Supreme Court. Right. So this case is a federal case, so it started in federal courts. Okay, so common law. So the judge in that case was forced to look at precedents. Precedents means previous decisions. And so because of our concept called stare decisis, he's bound to follow previous decisions that are binding authority. And so in this case, the binding authority is the United States Constitution, which is the 14th Amendment, which says everyone born in America, born on the soil, it's citizen. And so the 14th Amendment was created to give former enslaved persons citizenship because they were born here, right? And so that is one precedent that the court was bound by. The other precedent is the interpretation of a case by the United States Supreme Court. So the 14th Amendment, which was made in 1868, had its first challenge in 1898, and the case was United States' Wang. And so Wang was a Chinese citizen, but he was born. Both his parents were illegal, and when he tried to come back into America, he was stopped and said, no, you're not citizen because your parents were illegal. And so he went to court, and the Supreme Court ruled that the intent, the interpretation, is that if you are born here, regardless of your parents' legal status, you are a citizen. So that judge was also bounded by that Supreme Court case 127 years ago. So what usually happens now is when someone loses on a level of court, when someone loses on the first tier, then they will appeal to the appellate. So this case may be appealed to the appellate division, which will also be bounded by the Constitution and that Supreme Court case of 127 years ago. Now the Supreme Court, if the Supreme Court give writ of certiorari, which means 4 of the 9 justices must agree to hear the case. If 4 of the 9 justices agree to hear the case, only the Supreme Court can overturn itself, right? And so we see that that has happened where it overturned itself. And so this is why usually if you want the law to change, you challenge it knowing it's going to be overturned in hopes that it will get to the Supreme Court. For the Constitution, we meaning the United States is over 200 years old, and our Constitution has only been amended 27 times. 27. So it's not easily amended, right? It would take 2/3 of Congress and 3/4 of the states when it comes to having an amendment. But I hope that answered the question. I hope that shed some clarity on why the judge made the ruling that it did. Yeah. So I'm gonna talk to you later when I come back to the world of wills, trust, and estate. All right, but take care of yourselves out there, right? Hey, Isabella. Hey, Bella. Rude. All right, you guys. Document up, okay? Talk to you later. Ciao.